Good afternoon, Tiki Taki. I just wanted to add this video. I wanted to tag Baby RNE 2.0. I know she's been doing a lot of videos regarding courts and people questioning her on federal questions to the federal court, which is the Supreme Court. And what she has basically said is, if you raise a simple question in federal court with regards to the constitutional violations that a lot of these state courts are doing, which is leaving people in an interlocutory decree, which has zero remedies, right? Basically, what she's saying is to just pose the simple question of judgments. I would also pose the question of jurisdiction, right? So, because none of these state courts have jurisdiction, and in order for Congress to have passed or conferred powers, there's something by the word or the term congressional act. So, each specific court should have a congressional act if that is the case. But we all know a lot of these judges have been acting on vacation with no court, really, right? And so they're giving false judgments. So I wanted to kind of show this Chevron deference. And this is actually coming from something called the Government Attic. So this case here, and I'm going to read it to you so you guys can see what she's saying is actually true. And I'm just here to support what is being said. So with this, if we kind of go down here, and this is regarding basically this research that I pulled comes from the different maxims. And so for you guys, if you see here, it'll say intranet appellate maxims, you know what I mean? So here's what I found interesting. It says, under Chevron, if a court determines that Congress has directly spoken to the precise question at issue, right, then that is the end of the matter for the court, okay? As well as the agency must give effect to the unambiguously expressed intent of Congress. United States versus Hagar, Apparel Company, 526 U.S. 392, 1999, quoting the Chevron USA Inc. versus Natural Resource Defense Council, Inc., 467 U.S. 837, 842 through 843. If, however, the agency's statutory interpretations fills a gap or defines a term in a way that is reasonable in light of the legislature's revealed design, we give that judgment controlling weight. United States versus Hagar Apparel Company, right? And then it has another one, Nations Bank of NCNA versus Variable Annuity Life Insurance Company, 513 U.S. 251, 257. A statute may be ambiguous for purpose of Chevron analysis without being inartful or deficient. United States versus Hagar Apparel. For purposes of the Chevron analysis, a statute is ambiguous if the agency must use its discretion to determine how best to implement the policy in those cases not covered by statute-specific terms. Chevron's differences can be given to the regulations without impairing the authority of the court to make factual determinations and to apply those determinations to the law de novo. United States versus Hagar Apparel, because the courts of appeals confronted questions implicating an agency construction of the statute, which is administers a court should have applied the principles of differences described in Chevron USA versus Natural Resources. Thus, the court should have asked whether the statute is silent or ambiguous with respect to the specific issues before it. If so, the question for the court was whether the agency's answer is based on a permissible construction of the statute, We have recognized that judicial differences to the executive branch is especially appropriate in the immigration context where officials exercise especially sensitive political functions that implicate questions of foreign relations. If decisions by the Attorney General to deem certain violent offenses committed to another country as political in nature and to allow the perpetrators to remain in the United States may affect our relations with that country or its neighbors, the judiciary is not well positioned to shoulder primary responsibilities for accessing the likelihood and importance of such diplomatic repercussions. Okay? Now, if you keep reading, I mean, there's just so much information, but what I'm trying to say is, or how Baby RNE 2.0 is, what she's trying to tell you or tell people is, in order for a court, a high court, to respond to certain things where they have zero violations, right? I mean, where they have violations, basically, right? You have to impose a straight question per using the Constitution, right? And using your state constitution. So, with that being said, is if you impose the question, the courts must answer. I also wanted to touch real quick on the All Writs Act. And I'm not going to read the whole thing, but if you guys want to go through it, that's totally okay too. But here is basically what the writs eventually does is the All Writs Act invests a court with a power essentially equitable and as such not generally available to provide alternatives to other adequate remedies at law. Okay, and that's Clinton versus Goldsmith 526 U.S. 529 537. And it says, although the United States suggests that there is statutory support for the present injunction in All Writs Acts 28 U.S.C. 1651, we have said that the power conferred by the predecessor of that provision is defined by what is the usage and what are the principles of equity applicable in such a case. Grupo Mexicano de Desarrollo S.A. versus Alliance Bond Fund, right? So, I mean, ultimately, I guess what I'm trying to say is when you have been given a interlocutory decree judgment, it's not a true judgment and it carries zero enforceability. If you also look at 28 code, which is funny because when you bring up a federal question at the Supreme Court, they actually use this code here, which I kind of wanted to reiterate it. So they kind of use this code to basically impose your question in court. 28 U.S. Code 1333, Admiralty Maritime and Private Cases. But see, when you go in and you start reading, the district court shall have original jurisdiction. Exclusive, meaning exclusive in law means does not have. Of the courts of the states of. So state of Georgia, state of California, state of Pennsylvania, or Ohio. Things they don't have jurisdiction. So you're imposing a federal question at the state level, yet they already know they have no jurisdiction. So with that said, again, that's why it's important if your case has already rendered a final judgment, failed to give a statement of decision, things of that nature, which they must provide, right? This is how we hold people accountable. And so when you pose a question, you pose it using the Constitution because that is the law of the land and they must respond. That's simple. Don't complicate things. This is a shout out to Baby RNE 2.0. You're doing a good job. Keep on it. I hope you guys stay blessed. I hope this video helps. And see you guys on the next time. Bye.